It's July just after the end of Shabbat, and about 100 people have gathered in the Likud-majority West Bank city of Ma'ale Adumim. Hebrew University law professor Benny Porat, a resident of the city, is addressing the crowd.
הרוב הישראלי קם ואמר שאכפת לו, שהוא לא מרכין ראש, שהוא מוכן להיאבק על מדינת ישראל חזקה ומשגשגת, ושהוא יודע שהדרך לרשת את הארץ הטובה עוברת דרך מערכת משפט עצמאית שתקפיד על אמות מידה של צדק והוגנות.
During his 10-minute speech, Porat said, standing next to the police headquarters in Maaleh Adumim, statements such as the Israeli majority has risen up and will no longer be silent, even as a few of the West Bank city's residents attempted to drown him out. I sat with Porat in his home this week, and we discussed Tuesday's long-awaited and explosive High Court hearing over the first piece of the judicial overhaul legislation. We also talk about how Jewish legal tradition may help solve parts of this clash of the titans crisis. And so this week, I, Amanda Borshel-Dan, asked Professor Benny Porat, what matters now? Benny, thank you so much for allowing me to join you in your beautiful home here in Maaleh Adumim.
Good evening.
In this week, we have witnessed a long-awaited hearing in the High Court that we expected to be a clash of the titans, and to me it really was. So I ask you this week, Benny, what matters now?
What matters now? So first, of course, what will be the decision of the Supreme Court? Everyone now are waiting to hear what the Supreme Court will decide with regard to the basic law about the reasonableness and about its future. And the second thing that is even more matters, what will be the reaction of the government, whether or not they will recognize the authority of the Supreme Court to decide about that, or they will not recognize. This is a meeting of these two titans. Yeah.
So it really did seem to me that this is the question throughout the whole hearing. You mentioned the word authority, and I think the underpinning of this whole discussion is who gets the authority, who is allowed to decide what will happen, who rules the country in a way. Would you agree with that?
To some extent. No, I'm not sure that I think some of the, I would say, the supporter of the judicial reform will try to express it that way, that it's about the authority. I'm not sure that the opponents will describe it that way. It's more about the check and balances. So to what extent the majority and the coalition needs some check and balances from other entities, such as the Supreme Court, or not. So this is how it seems from the other side, and therefore this is about the authority of check and balances.
So one of the stars of the hearing was actually a piece of paper, the Declaration of Independence. And in the Declaration of Independence, in a way, the canonization of Israel as a Jewish and democratic state was written down, shall we say. Canonization, I'm using that word actually because of your specialty in law. So first of all, just explain what your specialty is, and then we'll move on.
So my specialty is about Jewish law, which is about the Jewish legal tradition for the last 2,000 or 3,000 years, and to what extent and to what ways it can be relevant to modern legal discussions, some technical issues and some principal issues. And of course, the issue of the judicial reform is very principal and matters to all of us. But about to what extent the Jewish legal tradition can be relevant to our modern life.
So were you surprised that the Declaration of Independence was so focused upon in some of the testimony and some of the presentations?
No, it's not surprising because it was mentioned before the hearing. And the reason that the Declaration of Independence is so important because those who are against the judicial reform are trying to look for some hook in order to limit the role of the government. And for that purpose, we need some formative paper, some formative thing. And the Declaration of Independence just sit there. This is a kind of a formative declaration that structures limitations and the authorities and to what extent the government can act. And therefore, it goes just to deep down to this paper and to what extent it has some authority about the government.
But the piece of paper itself and what's written there actually doesn't have any standing, correct?
This is also part of the debate. It doesn't have official standing, even though in one of the basic laws of human dignity, there is a recognition that Israel recognizes the idea of human dignity in the spirit of the Declaration of Independence. So this is a place where it has some official legal status, even though it's under debate. It's under debate what is the legal status of the Declaration of Independence. Of course, no one will argue that the Tikva, for example, has some legal status. The Declaration of Independence is much more complicated, and this is part of the debate. But what we have to remember, it's not a technical debate. It's not some boring debate of some law professors. It's something that go deep down to what extent the government has the authority to do whatever they want, or there are some limits, and the limitations are in the Declaration of Independence. Therefore, it's so important that the debate goes to the status of this declaration.
There's some who have proposed that it be adopted as part of the Constitution, and I wonder, in your specialty, if you can tell me whether religious leadership would recognize it as some kind of authority on par with, shall we say, I don't know, the Bible, the Ten Commandments. Would it have that much authority? Because here in Israel, we've been so reticent to creating a constitution. And I wonder if part of it has been some kind of religious sensitivity that nobody's really talking about.
So you mentioned the Ten Commandments, and it's very nice because, many years ago, and of course the debates that we have today are not new. We experienced them for several decades. So in one of the rounds, one of the Haredi representatives, I think it was Derry, but I'm not sure, said that I don't want even the Ten Commandments as the Constitution of Israel, because according to his view, it's unimportant what will be written in the Constitution. It makes the difference who will interpret the Constitution. And once the Supreme Court justices will interpret the Constitution, even though it is a Ten Commandment, it will be interpreted by their liberal, secular perspective, etc. And therefore, from this perspective, of course, we don't want the Constitution. We want it to be free enough for us, the politicians, to do whatever we want, and we don't want the constraints and the limitations of the Supreme Court and the Constitution.
So how much do you think this actually plays into this debate of whether Israel should or should not have a constitution? The religious parties are extremely powerful in the Knesset, especially right now. So is this a card that they're playing?
We have to remember that all of the mess that we are experiencing now is just because Israel doesn't have a constitution. Once we have a constitution, so we won't be in this kind of a mess and debate. And it's not by accident that we don't have a constitution, because we couldn't reach to the agreements about all of these basic principles, and most of them are relationship between the three branches. So between the executive branch and the judiciary. So it's not by accident that we don't have a constitution. And by the way, some of the supporters of this judicial reform trying to bring some example from other states, for example, from the U.S., and say, listen, in the U.S., the president has the authority to nominate judges. So if it's good to the U.S., why it's not good for us? So first, it's not works like that in the U.S. But second, it's more important, in the U.S. there is a constitution. And once you have a constitution and other mechanisms as well, you have two houses of Congress, and you have separation between the federal level and the state level. All of these mechanisms we don't have here in Israel. And first and foremost, we don't have a constitution. And therefore, the only one entity that can limit the government not to do whatever they want is the Supreme Court. And therefore, it's so crucial, this debate.
Let's talk a little bit more about the sensitivity, the religious sensitivity of having a secular authority interpret law in general. And you wrote an essay which talks about the concept of Adam Chashuv, and I think you called it a dignified person in English. First of all, explain what this concept is.
Yeah, so what I try to do in my research and with one of my colleagues about this judicial reform from a Jewish law perspective, and our argument was that the debates that we are experiencing today are not new. The Jewish community during the Middle Ages have the same debates. And the Jewish community, of course, it was not a state. It was not a modern state, but it was a political entity that was run by some politicians, which was called the seven good people of the town. And they, of course, wanted authorities, wanted power, they wanted to do a lot of things. And there was the rabbinical courts, which was a judiciary. And there were a lot of tensions between these two entities. And we can see how the Jewish legal tradition was so much importance in the idea that there should be independent judiciaries that put some limitations to the politicians. So, for example, one of the mechanisms that the Jewish law established for that purpose was the doctrine of Adam Chashuv, the dignified person, which is, according to our argument, is similar to the Attorney General, which is not a part of the court, but before, when enacting enactments in the Jewish community, according to Jewish law sources, then the politicians, the leader of the community, has to get the approval of this dignified person, which is the rabbi of this place or the one who is expert in law. And his purpose was to look for two things. First, that the communal enactments are aligned with the law. And the second one, that they're aligned not only with the interest of the majority, but with the interest of the whole community. These two things should be checked before enacting an enactment. And actually today, this is what the legal advisors and the attorney generals, they are our main role, to look that the actions and decision of the executive branch are aligned with the law in the general interest of the state. And from this perspective, it was so important for Jewish law that while we are recognizing the authority of the majority to control the community, but to put some check and balances, and the dignified person is one of them.
Tell us about other checks and balances throughout Jewish history on leadership.
So another very important mechanism, which is also very relevant for today, once the Jewish community enacted enactment, and someone felt that he's unpleasant, that he's being damaged or it's violated his right, he has a right to appeal to the rabbinical court. And the rabbinical court has the authority to overrule the communal enactments. So even though it was legislated by the majority, the rabbinical court had the authority to overrule this kind of enactment. And by the way, of course, the idea of override clause or something like that the majority can reenact something that was overruled, of course, it was it was non-option. So once the enactment was recognized that illegitimate, it was annulled. And this is something that also part of the judicial reform, to what extent the Supreme Court had the authority to overrule regular legislation, special legislation like basic laws. This is something that also part of the yesterday hearing at the Supreme Court.
As a non-religious person, I shudder inside every time you say that it's a rabbinical authority who had the final say. But it sounds to me like you're doing a one-to-one ratio with the civil authority that we have today. Is that correct?
Yeah, there is a kind of a jump here because, in the arena of the Jewish traditional community, so the judiciary were the rabbis, were the rabbinical court, and we are not living here today in an halachic state. This is a secular state, or at least non-religious state. So, of course, now one should ask himself, who are the modern Israeli parallels to this dignified person or to a rabbinical court? So one can argue that we want a halachic state and we want it to be the rabbis. So we can debate whether it's good or bad, but definitely this is not the current situation. So having said that, and if we assume that if we are in a secular state, my argument here is that we, as Israelis and modern Israelis that want some connection with our Jewish roots, need to think who is a modern translation of this dignified person. From my suggestion, this is a general attorney. Who is a parallel to the rabbinical court in the Jewish community? My suggestion is Supreme Court, and it's et cetera, in the sense that I think we should establish our check and balances mechanisms in modern Israel with some conversation with this Jewish past, and I think this is a very important infrastructure that we can derive a lot of insights, a lot of vocabulary, very interesting terminology and way of thinking in order to enrich our modern legal discourse. I would say it even from a different perspective. There are those who try to present the current debate between the Israelis and the Jews. The Jews represent a traditional, authentic Jewish perspective, and the Israelis represent a modern, secular, liberal, etc., etc. From my perspective, this is a very dangerous exposition. And my argument that also from Jewish perspective, these check and balances are very important, but we have to think about the modern secular translation of these Jewish ideas. And this is a deep meaning of being a Jewish and democratic state. Being a Jewish and democratic state, from my perspective, it's not only a state of the Jews, but also a state that has some interesting, open-minded conversation, which is a Jewish tradition, and mainly with its Jewish legal tradition.
I know that the Supreme Court has a legal advisor on Jewish law, Hila ben Eliyahu. And so is this something that she would be advising the Supreme Court on when they're reaching this kind of decision?
Definitely. This role is about, and we have to say that in the Supreme Court, mainly today, there is a lot of openness to derive some ideas and benefits from the Jewish legal tradition, and some expert needs to deliver, to bring these ideas to the knowledge of the justices. Not all of them are experts in Jewish law. Most of them are not. And this is a very important role. And we can see it in variety of Supreme Court decisions. The Jewish law take a very interesting role in shaping the decisions of the Supreme Court and bring very interesting voice, a very unexpected voice. And there are a variety of examples.
Is there a parallel position also in the Knesset?
Yeah, also in the Knesset there is such an advisor, and this is his task, and and also in the Department of Justice. So there are some this kind of positions also. In the university, in the faculty of law in Israel, it's a mandatory course. So what I say to my first year students, their colleagues in Europe learn at first year Roman law. And also in the UK, in Israel, we decided that instead of Roman law, we are learning Jewish law, which, of course, Jewish law and Roman law are the main ancient legal systems that shaped a Western legal tradition. So Jewish law, it's a mandatory course here in all of the faculties of law in Israel. And yeah, it takes a very interesting role, both in legal education and then in the Knesset, in the Supreme Court, in the Justice Department, and so on.
It's such a fascinating area, especially the brush with modernity and how you adapt the past into the present. You've talked about two examples so far. Do you have any more examples of how we can pull from the past into the present in our current crisis situation?
Here an example, which is not related to this specific crisis, but I think can give sense about the potential of going back to the Jewish legal tradition. And the Supreme Court of Israel in the last, I would say, 10, 15 years, had several cases, different cases, but what was common to all of them, that the deep tension was between, on the one hand, the right to freedom of speech, and the other hand, the right to reputation. And the Supreme Court had to decide between the two. For example, and there were several examples, there was a TV show about Hannah Senesh. Hannah Senesh is a great hero of the Second World War, but it was not a regular drama. It was called a docudrama, that it was a kind of a combination between document and drama.
Reenactments. And
the authors made a few speeches in the story, And as we all know, Hannah Senes was tortured by the Nazis, and she didn't tell the Nazis about her friends. And according to this movie, she was broken and she told the Nazis about her friends. And then the Senes family appealed to the Supreme Court in order not to enable this, to broadcast this TV series. And their argument that you are violating our or her right for reputation. All of us know that she was not broken when she was tortured. And of course, on the other hand, the authors of this series argue you're not serious about you're not about to censor some TV show. It's about the freedom of speech, freedom of art. And the Supreme Court had to decide between these two very, very basic values. And there are several examples. And what's very interesting in this discussion, and the rest of them, is that there was a lot of influence about what are the sources of inspiration of the justices. Those who was mostly inspired from American sources, of course, were a big supporters of the idea of freedom of speech, and where we will not limit any kind of freedom of press or speech or art. Those who was most inspired by Jewish law sources were great supporters of the idea of right of reputation and the idea that we are willing to limit to some extent freedom of speech in order to defend the right to reputation of some individuals. So there was an interesting debate between these two parts. In this specific case, the Supreme Court decided to allow the broadcasting of this case. In other, it was a different decision. It was depend about who were the justices and what's the ratio between the two. But what we can see in this example, how it's important to bring this a modern interpretation to Jewish law sources and to enrich the modern discussion from different and other perspectives that are not come directly from the US or Europe, but bring some very other interest, ideas, values, and sensitivities that we don't have today.
Many times we hear about situations in which the idea of women kind of causes a torpedo effect to legislation or to some kind of codification, such as the right to equality, for example. Or I also wonder if the fact that the Chief Justice is a woman and the Attorney General is a woman, if this is problematic in religious circles in terms of accepting their authority.
It's a great question. And I'm a big supporter of the idea to be inspired from Jewish law and to bring some insights and ideas. But of course, it should be selective. And it should be selective in the sense that we have to pick and choose and to see what fits modern society and what's not. And of course, this gender aspect, the status of women, this is a kind of an example that I'm not suggesting to derive ideas from Jewish law. Of course, Jewish law was developed before the feminist revolution. And of course, it might be updated to its time, but the Jewish law didn't experience yet the feminist revolution. And therefore, in this regard, I think that with regard to the status of women, I'm not sure that we want to derive ideas and principles from Jewish law. It is very interesting that, for example, Haredi MKs in Israel, they won't have a problem to collaborate with the Attorney General, even though she's a woman, or with a Supreme Court justice, etc. But they won't have a woman in their party. So there is a very strong and thick separation between the two. So while in their community, in their party, you won't find any women that don't have a problem to collaborate with secular women or with secular circles. And this kind of separation, which is, of course, it's very important. And this is another issue that we in Israel are struggling with. To what extent Israel can enforce political parties to have women in their parties? This is a very tricky question. Today, Israel are not enforcing that, but trying to give some incentive. So it's a very tricky question. Yeah.
Do you think that the women issue could be one of the reasons that we won't reach a constitution eventually?
It's about gender issues. It's about Jews and non-Jews, and especially it's about the status of some, I think, marriage and divorce. So marriage and divorce in Israel are controlled exclusively by the religious law. This is something that has its own reason on the one hand, but a lot of also disadvantages and a very problematic institution. So there are some pros and cons. And I think one of the basic fears that once Israel will have a constitution with recognizing the idea of equality, so it might be that marriage and divorce will not remain controlled exclusively by the religious laws. I think, yeah, it's relate in one way or another to some gender issues.
So this is all circling around the question, can we really have a Jewish and democratic state?
Yeah. In the bottom line, we go to this very deep question about Judaism and democracy, Judaism and liberalism. And of course, there are those from the two sides of the map that are trying to convince us that this kind of collaboration is impossible, because Judaism and democracy are in a very deep tension, and therefore we have to decide. So there are those who decide to be a democratic and non-Jewish state, and there are those who are trying to decide to be a Jewish and non-democratic state. And there is a very interesting meeting point between these two extreme views. I belong to those who believe that we have no other option but to find the meeting point between Judaism and democracy. Of course, Judaism has many interpretations. I'm not saying that there is only one interpretation, but it has many interpretations, and we have to choose to build the democratic interpretation of Jewish tradition. I think this is the only way that we can survive and prosper in this tough neighborhood, because we need to have a very strong, deep, and cultural roots, and the only way to do that is by having a deep conversation with our Jewish roots. And as long as we won't solve this kind of tension between Judaism and humanism or democracy, so we'll be doomed to be in this kind of tension. And this is the main task of us to do. So I think there's a Jewish Law project, for example, within Israeli academia, is one kind of trying to solve this kind of riddle, how we can give a modern and democratic interpretation to Jewish law ideas in a way that can support and not negate the idea of a democratic state.
You mentioned the two camps, and just to drill down on that, there's so many non-religious people who are so, I don't know how to put it exactly, so fearful perhaps of the encroachment upon their democratic values that anyone wearing a kippah at this point is now a target. And especially today when we're so up in arms over this judicial overhaul. And I have friends tell me that they walked down the street in Tel Aviv wearing a kippah and they were yelled at and spat upon. And this is also a wrinkle in everything we're talking about right now.
Yeah. There are some horrible sociological also aspects. There are some families that are find difficult to speak with one another, and of course the crisis now, it's not a polite academic crisis, but it goes to the streets, and I fear that we saw only the beginning of that, and therefore it's so important that I would say people wearing kippah, for example, like myself, I think, can expose a different, more complex, more nuanced, and more deep perspective. And we as a society should not fall into this kind of stereotypes. That if you are secular, so you are ABC, and if you are religious, so it's DEF. So it's so important to break this kind of stereotype and to think more deeply, more in a more complex way, more nuanced way. And this is part of the project. So, for example, we here in Ma'ale Adumim, there is a group of part of the demonstrations every Saturday night after Shabbat. it's a very unique demonstration. It's untypical. You won't find it not in Tel Aviv, even not in Jerusalem, because it's a demonstration of people that belong to the right. Most of them, part of them are religious, and nevertheless, they think that this judicial reform is a very dangerous move to Israel. And what we find is this helps in order to break these kind of stereotypes and to think out of the box.
So you're very vocally against the judicial overhaul, and you live, as you said, in Ma'ale Adumim, and it's a Likud voting city for the most part, maybe also other right-wing parties. And have you experienced any blowback for being so vocally anti-judicial overhaul?
So, of course, there's a lot of debates, but at least to my personal experience, I think the debates are being made in a very dignity and respectful, and I think till now we live peacefully together with my neighbors, with my relatives, even though we agree. So we agreed not to agree, and everything is okay, at least till now. But who knows what will be next week, next month, and there were some weeks that Israel felt that it's on the edge of a civil war. I think that we are far from there now, but it's a fear that is there, and we remember this kind of an option, and we should, of course, I think, not translate this ideological debate into some sociological separation between groups in Israel.
And that circles back to your opening remark, which is we're waiting for the decision of the High Court. Now, you have a very unique Talmud class that you conduct. Who are its members?
This is a very unique Talmud class that was established 60 years ago, before I was born, and it ran from then to today. It's a Talmud class that is aimed for judges, justices, and leading lawyers in Jerusalem. So I'm running this class for the last 8 years. It's a very interesting class. In this class sits very leading lawyers, some district judges from the District Court of Jerusalem, Supreme Court justices, some of them religious, some of them secular, and all of them has a very respectful feeling to the Talmud, and it shares the idea that is very relevant to our modern legal thinking. So it's a very interesting opportunity to bring sources from 2,000 years ago and to think about their meaning to our modern life. Great experience, and we enjoy it very much.
And has the crisis bled into this class at all?
It did. Yeah, most of the participants are against this kind of judicial overhaul. Some of them are supporters, but we're trying to separate between, our love to the Talmud and to the law, and our disagreement about the status of this judicial overhaul.
Benny, thank you so much for sharing your time with me. I appreciate it.
Thank you very much.
Really a pleasure.
Take care. Okay.
During that Ma'ale Adumim protest in July, the demonstrators participated in the great Israeli pastime of Shira B'tzibur, or communal singing. One of the songs they chose was Nomi Shemer's Lu Yihi, which was written 50 years ago during the Yom Kippur War. It's a prayer for the quick end to war, and this is a sentiment that rings true during the current crisis as well. Special thanks to Charlie Summers for his help with What Matters Now transcripts. What Matters Now is produced and edited by the Podwaves. Please go to timesofisrael.com/webinar to register for our next webinar panel, which is on September 20th, with former ambassador to the U.S. David Friedman, former MK Michal Kotler-Wunsch, and Professor Gil Troy, offering differing stances on whether or not the diaspora should take an active role in the judicial overhaul crisis. If you have comments about this or other episodes, please drop us an email at podcast@timesofisrael.com. Until next time, shalom.